Welcome to another episode of the Legal Lowdown. I am your host, Matthew R. Carpenter, an attorney, and today we are recapping some SEC enforcement actions that went down the week of June 2nd, 2025. Bear with me, guys. I am trying to catch up. Of course, we can listen to the SEC roundtables and read their press releases to get a basic understanding of what their policies are. But to really understand what's going down, we have to look at the cases and the regulations, people. And June 2nd, 2025 was, well, quite dynamic. It really showed the kind of constant effort needed in the financial markets. We saw this interesting mix of some older enforcement actions getting dismissed, but then, bam, several significant new cases being filed. So action on multiple fronts. It highlights how the SEC is, fighting existing fraud, but also trying to build frameworks for some of the newer stuff that I like. So let's dive into that, right? Starting with maybe the most traumatic case that I read. It's called SEC v. Cluetian. Cluetian. Based in the Federal District Court of Massachusetts, the complaint says that the defendant, Vladislav, a Russian and his confederates, hacked into firms to get non-public information. Hacking to get material non-public information, people, MNPI, regarding certain transactions and then using it to make money. A lot of money, in fact. The claim is an astonishing $82.5 million. Oh my gosh. This is like a virtual Ocean's 13. But anyway, so how did they manage that, right? Well, the reports say they set up 8 different brokerage accounts, apparently spreading out the $82.5 million to make it hard to track, I imagine. But here's a twist, right, that some of you probably didn't think about. So the defendant, Cluetian, was actually convicted in a parallel criminal action and sentenced to 9 years. But then, all of a sudden, President Trump issued an executive grant of clemency, ending the criminal sentence just like that. So you would think that Cluetian's case at least closed. No, not at all. And this is the key part, right? Because clemency ended the criminal sentence, but the civil action by the SEC kept going. The court granted summary judgment against Cluetian, as a matter of fact, in the civil case, which resulted in an injunction under Securities Act Section 17A and the Exchange Act Section 10B, ordering Cluetian to stop, plus disgorgement, right, making him pay back the profits. As for Vladislav, he was also ordered to pay disgorgement plus other penalties. So this case really amounts to a clear warning for high-profile defendants. It shows how the systems are separate. A pardon might stop jail time, my friend, but it doesn't just wipe the slate clean financially with the regulators. Interesting stuff. Okay, so let's shift gears from high-tech hacking to something maybe more traditional, right, but still damaging. Offering fraud, basically a Ponzi scheme. In this case, the SEC versus Cronus Financial Corporation. It's a case out of the Southern District of Florida, which was just filed in late May 2025. And this case involved Venezuelan clients. Let me back up. It involved an American and an American-based company finessing Venezuelan clients and depositing millions of dollars, including, some quite vulnerable people, into investing in funds operated by a company called Cronus. This is a Miami company run by Andrew Jacobs. Jacobs apparently or allegedly took roughly $17 million from the accounts he cultivated from these Venezuelan clients, and then he used it to make Ponzi scheme-like payments, right, to keep the scheme going. And then he also used it, the complaint alleges, not verbatim, but this is the gist of it, right, for his own personal tomfoolery. Good old tomfoolery. It'll get you every time, people. The complaint alleges violations of the Securities Act Section 17A and the Exchange Act Section 10B and Rule 10b-5, classic Rule 10b-5, as well as Advisors Act Sections 2061 and 2062. So the classic bait and switch, we've seen this a million times. Preying on trust, it's a reminder that, even with all the cyber threats out there, the emerging technologies, the old scams, abusing trust, they still draw attention. And the Trump administration, SEC, is going to go after you if you are breaking the law in that way. So we've got hacking and traditional fraud so far. But what about the really new frontier, the zesty cutting edge stuff, right? Crypto, blockchain, tokenization, all that. I saw, I think, a big dismissal involving Binance. That was notable. Hold on. The action against Binance Holdings Limited, that was dismissed, which Dismissal by the SEC usually raises questions like, why dismiss this case, right? Was there a specific reason tied to it? Well, if you've been keeping up with the SEC and the administrative changes and all that type of stuff, right? The SEC Commission launched a dedicated crypto task force, right? A task force, people, okay? To prop up crypto, no less, right? The goal isn't just enforcement, but actually developing a regulatory framework, a clear set of rules for crypto assets. So it's a strategy shift, okay? Instead of just, playing whack-a-mole with cases in the crypto Wild West, as some people allege was happening underneath the Biden administration. The new administration is trying to build a roadmap, acknowledging crypto is here to stay. And, it needs sensible rules. It needs nuanced rules. It needs to understand the contours and the nuances of what the crypto industry needs, right? Makes sense. So, one more enforcement type case before I hit the road. It popped up and was related to unregistered security sales. It was SEC versus Saison. I love Saison seasoning, but we're not talking about that right now. In this case, the defendants allegedly sold securities without an exemption or effective registration in place. So securities without the proper authorizations, people, you cannot do it. This is why registration is so important. It really boils down to investor protection. Like, registration means disclosures, telling investors what they need to know, right? Financial health, risk, who's running the show, all of that. And unregistered sales bypass that. And the Saison case shows the SEC takes it seriously, as they matter. So what happened, right, in the SEC v. Saison? Well, summary judgment was entered against the defendants, effectively ending the case, and substantial penalties were imposed. And I mean, we're talking disgorgement, people, of over $5.3 million. $5.3 million. The SEC is not playing. Plus individual and company penalties, right? So I think the individuals had to pay something like $90,000 each, and then the company ended up paying $500,000 on top of this $5.3 million disgorgement. So if you spent that money, it's gonna take you a long time to pay it back. And also, in addition to that, the defendants were barred from engaging in penny stocks transactions for 2 years. So it sends a very clear message, right? Follow the rules on disclosure or suffer the consequences. So yeah, a busy week nationwide for regulators. It all underscores that constant vigilance is needed, whether it's sophisticated hacking, old school fraud, targeting the vulnerable, or figuring out new assets like crypto. It's a complex securities landscape, people. Always shifting, always demanding attention. Wrapping this up with a nice, neat little bow. Think about all these different ways that financial systems can be misused. What are the takeaways for you, the listener, right? Given this constantly changing scene, what steps can you actually take if you're a client, if you're a company, if you're someone who wants to get into the securitization landscape? What steps can you actually take to stay informed or to protect your own investors, maybe even your data? You could consult an attorney like me, or you could consult a law firm, right? But you could also do some of this research on your own. Stay up to date, people. Stay educated. Just something for you to think about. Thank you for listening to this episode of The Legal Lowdown.